All right, Senator from Charleston, Senator Kempson, for what purpose do you rise?
May I be heard?
All right, on the perfecting amendment.
Amendment.
Yes, you can be heard on the perfecting amendment. Senator from Lawrence, for what purpose do you rise?
Distribute material.
Without objection, so ordered.
Thank you, Mr. President, ladies and gentlemen of the Senate. I'm concerned. I'm very concerned. The senator from Beaufort has authored an amendment, and he cites in support of the amendment and the bill the Prince case. Prince case is a Supreme Court case that was decided in 1996 when the ACA was moving through Congress and subsequently signed by the President. The Prince case was at the heart of the constitutional discussion of the Sebelius case, which upheld the constitutionality of the Affordable Care Act. Now, the essence of this nullification bill, and I'll repeat that, nullification bill, because that's essentially what it is. The state of South Carolina is thumbing their nose at federal supremacy, a well-established concept in this country. And all lawyers know that. Article 6 of the Constitution essentially says that once Congress passes a law and the constitutionality of that law has been decided, then that is the law of the land. And that is what the ACA is, the law of the land. And we all know that one of the seminal cases along that is Marbury versus Madison. But this preamble more concerns me to his bill because it cites the Prince case as the vehicle in which this senator from Beaufort is asking us to make these changes and nullify the ACA. The Prince case was a 5-4 decision, and it had to do with the Brady bill. And during that time, the Congress placed a number of obligations on CLEOs, which are Chief Legal Enforcement Officers. And in the Brady bill, they outline a series of requirements of these local officials. The local officials in Arizona and Montana appealed the Supreme Court, the Court of Appeals decision which upheld the Brady Act, and the Supreme Court reversed, and that was Prince. Now, the two people who were appealing, one from Arizona, and by the way, Arizona is accepting Medicaid funds. The other gentleman who's a CLEO is from Montana. And by the way, if you go to the state of Montana website, they have a website, Welcome to Montana. You can get your health care from the federal government. So in Montana, I know everybody wants to be like Montana, walk around with open carry, guns a-blazing. In Arizona, who just lost the Super Bowl. But even Montana has a website that points you to the healthcare exchange. So if we would adopt this amendment, people like MUSC, who visited me today, could not apply for grants to streamline healthcare costs. And most importantly for this body to know, there's no legal basis The Prince case is a 1996 case. The Sebelius case is a 2012 case. Yes, sir.
Senator from Lexington, what purpose do you rise?
And you to say
Senator, you
MUSC.
yield. Just a
Senator
second.
Yield.
You yield. Senator, you.
I yield. I yield.
Did I understand you say MUSC could not apply for federal grants
Under,
to reduce health care costs?
that's right. Under the, as I read the senator from Buford's bill, nullification bill, state agencies and political subdivisions cannot apply for funds under the ACA. Now, he disagrees with that. He can come explain it. But that's my perception of the reading of the bill. And so we have a number of entities who accept federal funds, a number of state agencies who accept federal funds that would be hamstrung. And even if they have a process that they have to go through under this senator's bill, we should not hamstring and place obstacles in the way of state agencies to maximize grants provided under the Affordable Care. Now, his amendment and the bill is now styled anti-commandeering. I submit to you that this is dangerous language for a state to even engage in this discussion. He didn't file a bill or an amendment when this governor yesterday indicated that she was going to apply for $54 million from the disaster relief. I heard the senator a minute ago just say we need more transportation money. Or do we anticipate a bill, an anti-commandeering bill, so we can accept federal money from the Department of Transportation? It's mighty funny that the situation presents itself that when we have President Barack Obama and a bill that has been passed in Congress and opined on by the 9 justices, one of which, Chief Justice Roberts, uses the Prince case. This isn't something new. Don't you think the lawyers who were trying to defeat the constitutionality of the ACA used the Prince case? They used the Prince case in Sebelius to strike down Medicaid expansion. As unwise as that is, but they left the states with the option. And even Jan Brewer understands that, the governor of Arizona. And so I am just very concerned, after being here for a little less than 20 days in this session, that our language, words matter. And when we talk about a preamble that starts out that this General Assembly finds that significant portions of the ACA constitute an unprecedented overreach by the United States Congress and the federal government, I'm concerned what that says to the rest of the nation. I'm concerned as a lawyer about us thumbing our nose at laws that have been decided as constitutional. I'm concerned about this state having over 786,000 people who don't have health care. I'm concerned about our ability to do our jobs to serve our constituents like MUSC, who's applying for grants, and many of our agencies who are applying for grants to maximize and streamline health care costs. And so I rise today to pause, and I want to make sure that all of my fellow colleagues understand the gravity and the importance of this discussion.